Good morning, or good afternoon. Welcome to Assembly Natural Resources. Madam Secretary, please take the roll.
Assemblywoman Anderson? Present. Assemblywoman Bilbray Axelrod? Here. Assemblywoman Brown May? Here. Assemblywoman Considine? Here. Assemblyman DeLong?
Present.
Assemblywoman Duran? Here. Assemblyman Gurr? Here. Assemblywoman Hanson?
Here.
Assemblywoman LaRue Hatch? Here. Assemblyman Watts?
Here.
Assemblyman Urick? Here. Chair Cohen.
And I am present. Again, welcome to Assembly Natural Resources. Some housekeeping before we get started. Please make sure and turn down your electronic devices. Please provide us with any exhibits the business day before any hearings by noon. Please note that committee members will be using our laptops and other electronic devices to communicate and review exhibits. Please don't take that as a sign of disrespect. Also, we do expect respect in this committee, whether it's to presenters, committee members, any members of the public. Also, today we will have 2 hearings, and then we will have public comment. We are going to start with SB 115. So with that, I will open the hearing on SB 115, which revises provisions relating to the mitigation of certain projects, and invite Warren Hardy to present, and also Mr. Parrish, Steve Parrish, who's General Manager of the Clark County Regional Flood Control District. So please, whichever of you is going to begin. And I will note that this is Senator Flores's bill, but he is right now in his own committee chairing. So with that, please go ahead.
Thank you, Madam Chair. Members of the committee, Warren Hardy, today representing the Clark County Regional Flood Control District. As was mentioned, the General Manager, Steve Parrish, is in Las Vegas, who will make some comments and then clean up after me with what I'm sure to mess up somewhere along the line. I want to thank Senator Flores for introducing this bill. This bill is designed to bring Nevada revised statute into compliance with some things that are happening on this front on the federal level. Many years ago, the federal government, the EPA, and the U.S. Army Corps of Engineers created a program that allowed for the creation of wetlands mitigation banks. And in 1999, the Nevada Legislature, through Senate Bill 217, allowed the use of mitigation banks, wetlands mitigation banks in Nevada. These mitigation banks allow permittees who are going to have impacts on wetlands or waters in the United States the ability to purchase mitigation credits from the bank that's been established, and that these funds are used generally by a third party, which is generally under current practice of a for-profit corporation, to do programs that offset the loss of certain aquatic resources and wetlands. Under the authority of SB 217 in 1999, Clark County created the Clark County Wetlands Park Mitigation Bank and utilized that mitigation bank for this purpose for many years. That bank has subsequently expired. The funds are no longer able to be purchased there. Part of the reason for that is that the federal government, the EPA, and the U.S. Army Corps of Engineers updated their regulations to allow these in lieu fee programs. So the in lieu fee programs are very similar, exactly similar, I should say, to mitigation, to the mitigation bank program. A couple of key differences. The first is that it allows the in lieu fee programs to be adopted by governments and nonprofits. So in this case, in our case, Clark County intends to create this in-fee mitigation program, which will take the public sector portion that goes to fund these for-profit companies out of the equation. So the more money will go to offset the mitigation of these programs. So this bill is very simply to bring us into compliance, or bring our statute into compliance with the newly permitted in lieu fee program. It will be administered by Clark County. The way the program works, we had a question in the Senate about whether or not these credits could be purchased by the general public and used as an instrument of commerce. They cannot. These programs are exclusively for this purpose. The county will administer it. If the mitigation program happens to be in Henderson, they'll work with Henderson. If it happens to be in Las Vegas, they'll work with Las Vegas. And all of the parties come together and collectively submit the application once it's been decided. And with that, if it pleases the chair, I'd like to turn it over to Mr. Parrish to see if I missed anything and maybe put a little more meat on the bones in terms of how the program's used, and then we'll be happy to answer questions.
Please go ahead, Mr. Parrish.
Thank you. For the record, Stephen Parrish, General Manager and Chief Engineer of the Clark County Regional Flood Control District, and we're located down here in Las Vegas. I want to thank Chair Cohen and Vice Chair Anderson and the committee for allowing me the opportunity to speak today. Mr. Hardy summed it up pretty well in his comments. If it's okay, I'd just like to quickly go over how Mitigation Bank works, just so the committee is aware of that if you're not already. Whenever any type of development occurs, whether it's a flood control project like the ones we do down in Las Vegas and Clark County, or it's a developer project like a subdivision or a commercial center, if there's an existing wash to that site, that wash has to be studied to see if it's jurisdictional under the Clean Water Act, if it's considered a waters of the U.S. If it is deemed jurisdictional, a 404 permit's required by the Corps. As part of that 404 permit process, any impacts to that jurisdictional area must be mitigated. And so currently the Corps' preferred method of mitigation is through a mitigation bank. There's other types of mitigation like in-kind, for example, but right now the Corps prefers that you use a mitigation bank for your mitigation. These banks are large-scale mitigation sites. They're approved by the Corps of Engineers and also the EPA. In accordance with the Clean Water Act. A local or state government or a private developer can mitigate potential impacts to the waters of the U.S. through a purchase of credits from the Wetlands Mitigation Bank. The bank then uses those funds from the sale of credits to complete the restoration or rehabilitation or even the creation of wetland habitat in some other location that's within the watershed of where the impact is occurring. The credits, as was mentioned by Mr. Hardy, are tightly controlled by the Corps of Engineers through the 404 permitting process, so they can't be purchased and sold for profit, for example, by a private entity. Current existing Nevada revised statute allows for the establishment of a mitigation bank. What this bill will do is revise the statute to allow, in addition to the Wetlands Mitigation Bank, an in lieu fee type of mitigation. The process to establish an in lieu fee program is nearly identical to the process to establish a wetlands mitigation bank. It's really just two means to the same end. The main differences between the two programs is that the Wetland Mitigation Bank, as Mr. Hardy mentioned, is operated on a for-profit basis typically. There's companies across the country that will set up these mitigation banks and then sell those credits and do the restoration projects, but they'll get profit off of that work, and that's how they operate their business. With an in lieu fee program, it allows us to use a nonprofit agency or a state or local government to manage the program. So in our case, we are going to ask Clark County to manage this in lieu fee program for us, the one that we're working on now. We've been working on this program with the Corps for about 3 years, trying to get it set up. We're getting close, but we needed this change to the NRS to help us with that. One other difference between the in lieu fee program and a mitigation bank is that the credits can be sold in advance to a public agency. So that actually helps the bank. It helps the manager of that bank because really a lump sum of funding could go to that bank that we could sell the credits. The lump sum would go to the bank, and then they could use that money for the restoration project that was developed as part of the establishment of the bank. One other thing this bill will do is just clean up references to the federal regulations that govern the establishment of the mitigation programs to make those references current. So to sum up, really the Corps and the EPA, both types, the in lieu fee and also the mitigation banking, are acceptable methods to the Corps and EPA to mitigate impacts to the waters of the United States. We would ask for your support on this legislation, and we look forward to any questions you may have. Thank you.
Thank you. I have a question from Assemblyman Watts.
Thank you, Madam Chair. Thank you very much for the presentation. So, and I appreciate the additional detail that was provided, particularly on how some of these mitigation programs work. I know that there's a variety, not just within this particular purview, but mitigation efforts and processes that are put into place. So while I appreciate that, I just want to make sure I understand what the bill is doing, and I do think that it was summed up pretty well at the end. But essentially, the number one thing it sounds like we're doing is aligning state statute with federal law and what's permissible under that, and making sure that our language doesn't conflict with that. And and in particular, adding the in lieu fee programs in addition to mitigation banks as mitigation pathways, because that is now clearly authorized by federal law. Is that correct?
Thank you, Madam Chair. Assemblyman Watts is 100% right. Warren Hardy, representing Clark County Regional Flood Control District. That's correct. We're now adding a tool to our state toolbox that is permitted by the federal government in the federal toolbox.
Assemblyman DeLong.
Thank you, Chair. Just a comment, I think making this revision and aligning the state statute with 33 CFR and 40 CFR makes a lot of sense to have a variety of mitigation options. The one question, though, is we are deleting the definition of mitigation bank in state statute. Are we losing something there we still need?
I'll allow Mr. Parrish, but my understanding is that's a statutory construction issue. If you notice, they are moving some definitions to another section of law. But I'll ask Mr. Parrish to confirm that.
I believe the way, Steve Parrish, I'm getting an echo, sorry. Steve Parrish, Clark County Regional Flood Control District. It's still, as the bill is written, it still allows for mitigation banking and also adds the in lieu fee program as well to that. There were some definitions that were deleted that were, I think, just redundant. And so there was some things added in Section 7 in terms of hydric soils and hydrophytic vegetation and that type of thing. So there were some definitions deleted, but the mitigation bank is still available after the completion of the changes to NRS.
Thank you. A follow-up. Yes, I did notice that hydric soils and wetlands were moved to Section 7, but the definition of a mitigation bank.
Assemblyman, we can ask our counsel.
Erin Sturdivant, Legislative Counsel Bureau. Federal law defines mitigation banks, so to the extent that the bill refers to those specific sections of federal law, they're set forth in federal law.
That's what I was going to say, Madam
Thank you.
Chair.
Thank you. I just had a question if there are timeframes in the federal law when this mitigation happens, or when, if with this fee in lieu from the time that those credits are purchased to any restoration made, or the flip, if there's any timeframes that all needs to be done.
Thank you, Madam Chair. I'll take a shot at that and then defer to Mr. Parrish. My understanding is that these federal regulations have been adopted as part of 33 CFR, so we are now just adopting them into the state statute. So both programs are currently available under federal law and regulation. Did I miss the?
So then you're saying if there are any timeframes, it would be under the 33 CFR?
Correct.
Thanks.
And I'll allow Mr. Parrish to correct me if I'm wrong.
Yeah, for the record, Steve Parrish, our Regional Flood Control District. as part of the mitigation bank process, there's a whole instrument that's prepared to support that, and that spells out any timeframes that would be required in order to get the restoration projects done. And there's also timeframes in terms of how long they got to monitor that restoration project to make sure that it's viable and is okay. So they're kind of laid out within the documents themselves as the mitigation bank is approved by the Corps and EPA.
Just to respond to the Assemblywoman's question, yes, there would be a permit that would be issued by the Corps of Engineers under Section 404 that has specific requirements for having mitigation established as part of executing the permit.
That's what I was going to say.
And that was, for the record, that was Warren Hardy. Okay. And then, so earlier today, we spoke in my office about possible projects, and because I'm always happy to talk about Pittman Wash, can we just kind of talk about the process and how that would work, about how basically oh wait, what did I want to say? I wrote some notes about how we're going to need to, for these projects, we're going to be using the same watershed, right? You want the project to be within the same watershed, but for Vegas Valley, it's all considered the same watershed. So you could possibly have a project on one end of the county, but you could end up doing the project for restoration on the other end of the county. And just some of the things that you're possibly planning with this.
Sure. For the record, Steve Parrish, Clark County Regional Flood Control District. So it's a requirement of the Corps when we do one of these mitigation banks that the mitigation actually occurs within the watershed area of the impact. And so we are looking at a couple of different locations. One of them, as you mentioned, is the Pittman Wash. I think we're also looking at some projects up along the Virgin River. And so when the Corps reviews our mitigation banking or in lieu fee program documentation, they're asking us where these projects are going to be to make sure that they're close enough in their view within the watershed to offset the impact to the jurisdictional water.
Thank you. And can you just tell us what some of the different projects are? What kind of restoration is being done?
Thank you for the question. Again, Steve Parrish, Clark County Regional Flood Control District. So the Pittman Wash is one area that we're looking to do a rehabilitation of the habitat. There's a section of Pittman Wash, it's about 2 miles long, kind of down by Valley Verde, that is planned to just remain in its natural condition. There's no plans in the future to do any type of lining for flood control through that area, and so it's just going to remain natural. And the Friends of Pittman Wash is a group, and the City of Henderson also has been trying to improve these areas and remove invasive species and that type of thing. And so this plan, it's yet to be developed. We're still working on it, but we'll hire a consultant that will go in and analyze what needs to be done within that Pittman Wash area to make it a better habitat for wetlands and for vegetation and animals and birds and that type of thing.
Okay, thank you. Do we have any other questions? Okay, seeing none, thank you both for the presentation. Do we have anyone for support in Carson City? And then if there's anyone else, are you alone in the room in Las Vegas? Okay. If there's anyone in Elko, I don't think there is, but they can fill the chairs. Please go ahead.
Thank you. Good afternoon, Chair Cohen and members of the committee. My name is Jeff Rogan, and I represent Clark County. We are in support of this program. We think it's a great addition. It provides greater flexibility to mitigate the impacts of development, whether, as was mentioned, by the flood control district or the development that happens every day, every month in Clark County. So having this in lieu fee program does provide us a mechanism that didn't exist before, and we urge your support for SB 115. Thank you.
Thank you. BPS, can we go to the phones, please?
Chair, the public line is open and working, but there are no callers at this time.
Thank you. Do we have anyone in opposition in Carson City? Seeing none, seeing no one in Elko or Las Vegas, BPS, if we can go to the phones for opposition.
Chair, there are no callers at this time.
Okay, do we have anyone in neutral in Carson City? Seeing none, seeing no one in Elko or Las Vegas. BPS, if we could go to the phones for neutral?
Chair, there are no callers at this time for neutral.
Okay, gentlemen, any final remarks?
Just thank you, Madam Chair. Warren Hardy, thank you for the hearing, and thank you again to Senator Flores for bringing this forward before us. Thank you.
Thank you. With that, we will close out the hearing on Senate Bill 115, and we will open, well, I guess we won't open the hearing yet. We'll go into a brief recess, and Senator Orenshaw, if you're listening or your staff is listening, please come up. So we'll come back in as soon as we can get a presenter here. With that, I will open up the hearing on SB 258, which revises provisions related to water, and welcome Senator Orenshaw, as well as Michael DeLee, who is presenting via Zoom, and Mr. Jared Horn. And please go ahead when you're ready.
Thank you very much, Chair Cohen. For the record, James Orenshaw, I represent Senate District 21 down in Southern Nevada, and proud to be a former member of this committee. Hopefully that'll butter you all up and you'll all be nice. But I always have fond memories of serving this committee under former Assemblyman Jerry Claiborne, who was Chair of Natural Resources a long, long time ago. But I always loved this committee and getting to serve on it. Very happy, and thank you for hearing Senate Bill 258. It is a proposed change to Nevada water law. With your permission, Chair Cohen, I'd like to turn it over to Jared Horn, who is a student at University of Nevada, Reno, part of the Political Science Department, and an intern in their legislative department on legislative affairs. And he's been helping me with this bill. Then I'd like to, with your permission, turn it over to Mr. DeLee, who's appearing via Zoom from Nye County. And then I'd be happy to answer any questions the committee has.
Good afternoon, Chair Cohen and members of the Assembly Committee on Natural Resources. For the record, I'm Jared Horn. I'm an intern for Senator Orenshaw. I'm a student at UNR for political science. I appreciate the opportunity to help present Senate Bill 258, which is one of many bills related to water to come before the committee this session. Senator Orenshaw decided to introduce SB 258 to provide certainty that renewable energy projects could be developed while maintaining certain statutory guidelines regarding notice and the right to protest said projects. It passed and really received unanimous support on the Senate floor. And with your permission, Madam Chair, I'd like to turn the presentation over to Michael DeLee, who's joining via Zoom.
Please go ahead, Mr. DeLee.
Okay, got it. Thank you. Thank you, Madam Chair. For the record, Michael DeLee. I'm honored to be here presenting today. I thank you for the accommodation. It's not always easy to get to where you are, but technology certainly helps nowadays. This is an important measure to facilitate projects for renewable energy. The projects are getting larger, and the construction time for these projects are going well over 1 year. That complicates permitting for these projects because one of the things that they need to prove they have is water for construction. A great many of these projects don't use any water at all after they're built. It's only primarily for dust control and road construction during the project itself. So at the end of the project, the water needs to go back from wherever it was borrowed from. And that becomes difficult when there's a lot of uncertainty involving the administration of water rights. So there is a provision now for temporary change applications, but it doesn't really fit when projects go over 1 year because there needs to be permitting and approval for funding, and banks like to make sure that projects can get built and not get hung up for lack of a permit. So we've got an important piece of legislation here that's going to make a good fit for that, and it's very appropriate for this. We didn't need it before because this wasn't happening before. So I appreciate your support and happy to answer any questions.
And thank you, Chair. James Orenshaw, State Senate District 21. Again, I think that Senate Bill 258, if it passes, will help develop these clean energy projects and provide certainty that they can start and they can finish and they can get built. And I'm happy to answer any questions.
I have a question from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for coming and presenting today. So my question is just about the process, and if you could just explain a little bit more why it is problematic for these projects to reapply for the permit. I would imagine that there's many projects that go on and have been going on, and they reapply every year. So if you could just walk us through why 3 years is more appropriate than 1 year.
Thank you. Through you, Chair Cohen, to Assemblywoman LaRue Hatch, James Orenshaw, State Senate District 21.
And please feel free to go directly to the member.
Thank you, Chair. Assemblywoman, as I understand the situation now, there's a lack of certainty for a lot of projects that need to get developed as to whether there will be enough water to complete the project. And this window of a minimum of 1 year to a maximum of 3 years will provide that certainty. And I think it will also be beneficial for other interested parties, because if this passes into law and a renewable energy development company or developer wants to try to get this temporary water permit for this project of 1 to 3 years, it's going to be subject to everything that's in the law now in terms of notice, the right to protest, and I think it's good for the development of the project. It's good for all other interested parties. If there's someone who's got an objection, they'll have a right to be noticed and make that objection. And Mr. DeLee or Mr. Horn, if either of you'd like to jump in with your permission, Chair.
Sure, I'm happy to add to that if you may.
Please go ahead, but please just state your name.
Thank you. Again, Michael DeLee for the record. The senator's absolutely right. This is about reducing risk to enable the certainty of construction of renewable energy projects. Reducing the risk is part of the entitlement process to make sure that things are going to be funded and continue throughout the life of the project. And one of the concerns is the statute as it exists now contemplates a 1-year timeframe for a temporary application. And when it exceeds 1 year, it's not really appropriate to ask for something that is really 1 year and then come back and ask for it again, because there's always the uncertainty that you're not going to get it. Additionally, that might be interpreted as trying to get around some publication provisions. And there are people that are very concerned about these projects and would like their voices to be heard at all phases of the project. So ensuring that these longer and bigger projects are going to be published and follow the water law under 533-360, for example, for the contents of the publication, like any other water right change application other than a temporary right, that protects the public that may have an interest in whether these are environmentally correct projects.
Assemblyman Watts.
Thank you very much, Madam Chair. Thank you for the presentation. So I guess just going back to that, and first of all, I appreciate the more robust noticing and participation requirements that are envisioned for an extended temporary permit. My understanding, though, is that there are frequently temporary permits or temporary changes that are renewed for more than 1 year. So I guess just following up on the questions that my colleague asked, so you mentioned risk. Are renewable energy projects not having their temporary permits renewed? Is there a problem with those not being renewed that requires an extension of time to 3 years?
And Assemblyman Watts, if I can go direct, James Orange, State Senate District 21. On this one, the reason we went with the 1 to 3 years was to provide certainty for development of these clean energy projects. And as to that particular question, I'm not sure if Mr. DeLee can jump in on that one, or I don't know if anyone's here from the state engineer's office who might be able to testify in neutral. But the reason I'm pursuing this is for that certainty, for not having the uncertainty as to whether it will be renewed or not, and trying to make sure these projects can go forward for clean energy. And Chair, with your permission, I don't know if Mr. DeLee wants to jump in or not. But.
I can address that, yes.
Go ahead, Mr. DeLee.
Thank you, Madam Chair. And to Assemblyman Watts, Michael DeLee for the record. I was involved in a approximately 100 megawatt project in Nye County. And one of the criteria that was expressed during the planning for that project was that the water rights involved for dust control needed to be water rights that were not from the temporary, 1 year temporary, and relying on a 1 year extension. That was a discussion during that project, and it was a concern. And this has been come up several times. They said, well, it looks like we may have to approach this and clarify it. And there was a previous effort made to clarify it, didn't get as far as we have today. There's been a lot of additional projects announced since the announcement of large transmission projects to serve these. So it's pushing everything forward. It's a priority now throughout the state, and it's going to be even more important that we have this. So to date, I can tell you that one from my own personal experience, how other projects have been constructed. A lot of that has to do with trucking water from existing sources, so you don't have to change the point of diversion of the source. A very large project in the south end of Nye County, for example, going in now, and that's literally being trucked from an existing source. So that's not very economical. If you can pump from a closer point of diversion, it's going to save a lot of emissions in the atmosphere and a lot of trucks rolling on the highway if you can avoid doing that. So but the problem is the certainty of moving that water back to its original source when the project is done. And if you don't have that certainty, you can end up with water that's stranded. And we've also seen that where an entity leased water for a period of 5 years. And during that lease, the administration rules for that particular basin were changed, and that water got stranded there, and they ended up having to purchase the water rights. So we're looking for certainty for the developer, certainty for the owner of the water rights, and predictability for a large renewable construction project.
Thank you. May I follow up, Madam Chair? Thank you. I appreciate that, and I still wonder if part of that might just be communication or other issues, because again, I think I understand the need for certainty, but I'm not. So it sounds like on the front end of planning projects, or proposing some things, those concerns have been expressed, but it's unclear to me if on the actual administration side, if there are any barriers to getting a 1-year extended. So I'll also follow up offline and follow up with the state to make sure that my understanding of that is clear. The only other question I had is why is this envisioned as specifically being for renewable energy projects and not for other forms of temporary change applications?
Assemblyman Watts, James Orenshaw, State Senate District 21. You know what, this is limited to renewable energy projects as defined in 701.080. And I think back to, statement when we still had Senator Reed with us about Nevada having the potential to be the Saudi Arabia for solar. And I think that little by little, we're seeing that. We're seeing, more renewable energy projects get built and more energy being produced that doesn't have a carbon footprint. I think that this bill will try to help that become a reality, what Senator Reed had envisioned so long ago. And that's the goal of this bill.
Thank you, and I completely share that goal. I'm just wondering why it's envisioned for this, but not for other potential applications.
James Orenshaw, State Senate District 21. That's Senate Bill 258. That's the problem I'm trying to solve for renewable energy projects.
I have another question from Assemblywoman LaRue Hatch.
Thank you, Chair. My colleague's line of questioning made me think of another question. So I do have some concerns when we are removing oversight on water, which is our most precious resource. And so my question is, if we put this in for renewable energy generation, are we now setting a precedent that next session we're going to come back and somebody else gets an exemption, and then the next session somebody else, and we just piecemeal this one by one as we're getting all these industry exemptions?
Thank you, James Orenshaw, State Senate District 21. I appreciate the question, and certainly I'm not an expert in water law, but as I understand it, if Senate Bill 258 passes, there'll be more oversight. If a renewable energy project wants to seek this temporary permit within a window from 1 year to 3 years, that will be subject to the notice provisions currently in statute, publication, the right to protest for anybody who feels that this is not something that should happen. And as I understand it, that certainly doesn't happen with the permits that are less than 1 year. So I think there'll be more oversight, more notice, more certainty for someone developing the project, more right to protest and be notified about that if someone believes this is not something that should happen.
I'm sorry, Assemblywoman Hanson, were you trying to catch my eye? Okay, committee, do we have any other questions? Okay, I think the committee members kind of got my questions. So, all right, with that, we will, unless you have anything else to add, we will move on to support.
Thank you.
Okay, so is there anyone in Carson City for support? Okay, seeing none and seeing no one in Elko, if anyone in Elko or Las Vegas is there for support, please come forward. Seeing none, BPS, if we have anyone on the phones for support.
Chair, the public line is open and working, but there are no callers at this time.
Okay, do we have anyone in Carson City for opposition? Okay, seeing none, anyone in Las Vegas or Elko for opposition? Seeing none, BPS, do we have anyone on the phones for opposition?
Chair, there are no callers at this time.
Okay, then anyone in neutral? In Carson City? Anyone in Elko or Las Vegas? Seeing none, BPS, anyone on the phones in neutral?
Chair, there are no callers at this time.
Okay, with that, I will invite the presenters back up to make closing remarks.
Hello, Chairwoman Cohen. Jared Horn for the record. We appreciate the committee allowing us to bring this bill forward and present it. I personally appreciate allowing me to come up and have this experience assisting with it. And that'll be closing.
Yeah. And Chair Cohen, James Orangel, Senate District 21, thank you very much. Thank you for letting Mr. Horn present this, his first chance of presenting a bill. It's a wonderful program UNR has, and one of my favorite former legislators is coordinating that program, Dr. Joyner, and thrilled for that. I appreciate the committee hearing this bill. I believe this bill will help promote clean energy, certainty for those who want to develop clean energy in our state, and additionally provide notice, opportunity to protest for anyone who believes that this temporary transfer of a water right should not go forward. I believe this is good for development of clean energy, good for the public. I hope the committee would consider it. Thank you.
Thank you, and thank you, Mr. DeLee, and especially thank you, Mr. Horn, for coming and presenting with us. We're very happy that you were able to present the bill. Thank you, Senator. Okay, so with that, I will close out the hearing on Senate Bill 258, and we will go into public comment. Is there anyone in Carson City for public comment? Seeing none, is there anyone in Las Vegas or Elko? Seeing none, BPS, do we have anyone on the phones?
Chair, the public line is open and working, but there are no callers at this time.
Okay, thank you. With that, we don't have a hearing set for next week, but I'm sure we will be setting one. And with that, we are adjourned. Thank you.